So another question that we're getting is related to the stimulus as it relates to the Payroll Protection Act that was put into place under the CARES Act, and how that might be dealt with. So Kelly, can you kind of shed some light on what that question is?
Yes, so we have a lot of individuals who own small businesses. So the question came up as to if one of the small businesses is involved in a divorce proceeding, if that business receives a loan under this new act, a loan under the Relief Act, is the other party, the non-business owning party, are they liable at all to repay any of that money that's not forgiven?
So Rob, do you have any insight that you could shed on that question?
Sure. So I think the easiest way to initially look at this question is to just kind of take the crisis out of it and just look at what if we have a business that, needs a loan, and how would the court, how would people want to respond to that? How would the parties want to respond to that? I like to tell my clients that once you file for divorce, all debts that you incur after that filing period are essentially going to be your debts. There's obviously some situations in which that may not be the case, but for the most part, if you open up a credit card, if you borrow money, take out a loan, that's going to be your financial responsibility post-divorce. So I would advise that my client who has a small business, if they were taking out a business loan in accordance with this the stimulus package, that odds are it's going to be the business's financial responsibility, and then therefore the distribution of the liability will go in accordance with how the business itself is divided, if it's divided at all in the divorce. I understand that probably the biggest issue we're going to face with this is the time sensitivity to getting a small business loan, given the current crisis. So in this situation, I would definitely want to advise that the parties sit down and recognize the severity of what's going on and the need to likely apply for a business loan to keep the business afloat, because again, a business will be considered a marital asset, and the higher the value of the asset, the better it is for all parties. So if the small business loan is what's going to keep that asset at a high value, it's beneficial to everybody. So to answer the question directly, I think it is one of those things where it's a case-by-case basis. We need to understand what exactly the loan is being used for. Any of the agreements by the parties prior to a loan being applied for, and of course how the business will likely end up being divided among the parties at final divorce.
And not to throw another wrench in here, Janelle, but before you go on and add some context to that, under the Payroll Protection Act and the SBA portion of that as it relates to loan forgiveness, typically loan forgiveness is looked at as a taxable event when a loan is forgiven under IRS Tax Code 1986. Under this current loan, they actually strike that. It is a non-taxable event, and essentially the portion forgiven is no longer looked at as income. It is essentially just forgiven 100%. No taxes are accrued on that. So, parties going through a divorce that own a small business that may take out a loan, how might that really be addressed in court? Because that there's really nothing written on that. And how might we talk about that with the court as it relates to how we're going to divide this and value it? Because there's obviously, if depending on the size of the small business, that can be a sizable amount of money. The max loan amount is $10 million, and that's for small businesses with less than 500 employees. So, if the business utilizes those funds appropriately, that essentially becomes a non-taxable event at a large dollar amount. That could be a benefit to that business overall. So, can you kind of address how that might be litigated in court and kind of how we might position ourselves?
Sure. I mean, first and foremost, I would expect, and typical orders entail, that during the pendency of a divorce, any party that owns and operates a business should continue to conduct business in the ordinary course of business. And I think that this would absolutely fall within those parameters, especially since the purpose of this stimulus is to prevent small businesses from going under. If the business collapses upon itself because it can't meet payroll obligations or expenses, then obviously we don't even have an asset to talk about here. So obviously both parties have an interest that these funds be available and be utilized for that purpose so as not to jeopardize a marital asset. So we need to keep that focus in mind when we're talking about, is this an appropriate opportunity for the business owner to utilize? And I think in most cases, a court would find that it is, if they have that demonstrated need.
Mhm.
So when we look at the allocation of that debt, I absolutely agree with Rob that it's going to stay with the business as it is a business loan. However, I think that this is going to complicate things very significantly in terms of how do we apply that to the value of a business if there is value there that's being divided for the purposes of final property division. And so I think if I were the party not owning the business, I absolutely am going to want to raise the issue that potentially some or all of that loan can be forgiven without any penalty and any implication to the business owner after that period of time. What I expect to come from this is actually carved out provisions that allow for a review of that issue down the road. I've seen this in novel cases, not like this, because we've never run into something like this, but when you do have kind of a question that can't be resolved because of the timeline that we're dealing with, we can carve out clauses that allow for review after the fact to determine, was there an additional amount that should have been distributed to the parties because of a factor that we did not know or had not decided at the time of the final judgment. I think this is exactly one of those things that if a judge were inclined to entertain the fact that a new loan might exist against the business, that I would, on the other end, ask the court to allow for review after the timeline necessary under that loan provision to determine whether or not any of those amounts were actually due and owing and paid back. If they were forgiven, then I would argue that that value that was deducted from the business at distribution and division should be added back in, and the spouse that did not receive their share should get that 1/2 of whatever was deducted.
Katie, anything to add there as it relates to kind of how you would think through this?
Yeah, I'll just highlight some of the things that I agree with that Rob and Janelle have stated, and then just add a couple notes myself. So in Illinois, for any pending divorce case, the courts are always going to be concerned with maintaining status quo. So what Janelle had said earlier about continuing to conduct business, I think that is definitely applicable here as well as what both Rob and Janelle had indicated with respect to cooperating regarding the loan. Clearly, each individual case is going to be looked at uniquely and differently. However, I think as a general statement, we can say that if this is going to benefit the business and maintain that asset, I do think that a court is within, I think the court absolutely has the discretion to indicate that both parties should cooperate with respect to the loan. And then the thing that I actually think is a little bit nuanced maybe in Illinois is, it's been my experience that after you file a petition in Illinois while a case is pending, even if there are debts incurred by either party, they can actually still be considered marital debts subject to allocation between the parties. Clearly, there are different examples of that. Like if someone unilaterally goes out and incurs significant credit card debt, then I do think the likelihood that they would absorb that debt increases. But with a debt like this through a business, it still can definitely be considered a marital debt subject to allocation. So I think that with any business or any situation involving a business, yes, the debts typically stay with the business, or they'll be considered with respect to valuation. Again, based on Tony's feedback with respect to the non-taxable event, I honestly think that my analysis would be each particular case is going to be unique and individual, and whatever arguments that we're going to be crafting as attorneys are going to be new because this is completely unprecedented.
Yeah.
So I think it's going to boil down to each case is going to be unique. We're going to have to think outside the box and be very creative in terms of the arguments that we come up with. And that's kind of what my response would be to that question.
Awesome.